weekend for a vote session. We have received a concurrence of House Bill 824 from the Senate. Could I have a motion on the concurrence, please? There's a motion to concur in the Senate amendments and a second. Is there a discussion in concurring on the Senate amendments? Delegate Grammer.
There we go. Can we talk about what the amendments do?
So, as I understand it, and do we have the interlineated version of the? Well, you've got. There are amendments that I can go through. The bill, as it left the House, said that you would be prohibited person while you were on probation, supervised probation. That remains for a violation of a 21902B or C, or I'm sorry, I'll get to that in a second. For a violation of a driving while impaired charge, or a driving while under the influence of drugs and alcohol charge, or a violation of the protective order statute. The JPR committee changed that to clarify it to say that they had to be on a supervised probation for after a conviction for those things, not just a violation of those things. So they clarified that location, or that language. They add language that says that on or before October 1st, 2024, and each October 1st after, the Sentencing Commission shall report to the governor in accordance with the state government article on the number of charges, convictions, and sentences for violation of the wear-carry statute and of 5133D of the public safety article. The information included in the report shall be disaggregated by jurisdiction, race, and gender. The Department of State Police is to transmit to each email address on file with the department that is associated with the purchaser or transferee of a regulated firearm, or a person who has registered a regulated firearm with the department, a summary of each new law or change to existing law pertaining to firearms that was passed in the General Assembly during each legislative session. So they have to tell them what new laws are there. It has to go out within 45 days after the General Assembly adjourns sine die in a legislative session. For each act establishing a new law or change to an existing law 30 days before the effective date of the act. Well, it sets timelines for when the information has to be provided. So let me restate that. It has to go out 45 days after the end of sine die, and for each act establishing a new law 30 days before the effective date. So if there's a change to an existing law, they have to note it 45 days. If they have an act establishing a new law, they have to do it also 30 days before the effective date of the law. They lower the increase in the fees from what we passed of $150 for an initial filing and $100 for a renewal to $125 and $75. They amend into the bill the language that was in SB 1 for training that was then stripped out of SB 1 as we passed it. So it includes the Senate's language with regard to training that indicates that people have to learn about self-defense, state and federal firearm laws, including laws related to self-defense, defense of others, defense of property, the safe storage of firearms, the circumstances under which an individual becomes prohibited from possessing a firearm under state and federal law, including having a protective order taken out against you, or an ERPO or a red flag order taken out against you. The requirements and options for surrendering, transferring, or otherwise disposing of a firearm is in the training. How to report a loss or theft of a firearm, the firearms and firearm accessories that are banned under state and federal law, the types of firearms that require a special permit or registration to acquire or possess under state or federal law, straw purchase law, the law concerning armed trespass, and the locations where a person is prohibited from possessing a firearm regardless of whether a person possesses a permit issued under the subtitle. It also includes training on home firearm safety, handgun operations, conflict de-escalation, anger management, and suicide prevention. In a later part of these amendments, I also believe that it includes that the state police, as we had discussed, along with the Attorney General, along with the state police and others, will be putting together a curriculum for the trainers so that they know what they have to teach in these things. It does include a firearm qualification component. And as I just mentioned, the Secretary of the State Police, along with the Office of the Attorney General and the Department of Health, shall develop, publish, and update and distribute to all state-certified firearm instructors a curriculum of instruction for the topics required for classroom instruction in this section. It changes on page 11. Convicted after, okay, this is, I think the storage language, it makes a change to the, it makes a change consistent with the storage bill that we just passed, in that it changes that from 16 to 18, so that's consistent with what we've already passed. It includes the language that we passed in 824, but I think they tightened it up a little bit, so it provides the information about who is being rejected or for getting a wear carry permit. All of that data, it again says that it's got to be disaggregated by county of residence, race, ethnicity, age, and gender. And I'll be with you in just one second. I just want to make sure I get through all of the rest of them. It also includes a section, and this is the last part, includes a section that the provisions of the Act shall be construed to apply only to an initial application or a renewal application for a permit to wear and carry that is submitted to the state police on or after the effective date of this Act. So in other words, it doesn't apply to the people who apply before the initial date of the Act, just after it. And those are the Senate amendments. Delegate Grammer. Can we have your mic? Let's get.
There we go. Thank you. So the portion that you mentioned about the reporting relevant to wear and carry, was that just the reporting to the interested parties so they understand the updates to law, or were there also reporting requirements so we have a greater understanding of who's getting permits? Are there any violations? We talked about this briefly a couple days ago.
That's already in the, so 2 reports and information in the 3 things. 1, it requires the Sentencing Commission to provide the General Assembly information on the number of charges, convictions, and sentences under the wear carry statute. 1, 2. Already in the bill were the number of people who had applied, data about who has applied, who was rejected, and who has had their permit revoked. That is still in the bill. I think they tightened the language a little bit with regard to those things. And then 3, it requires the state police after the end of the General Assembly session to send an email to whatever email they have on file for people who have registered a firearm to tell them about the new bills and provide them information about what we had passed.
Okay, there was a small portion about firearm qualification. Can you clarify that, please? So
qualification, that goes to the training course, and this was the language that was passed by the Senate in SB 1 that was excised from SB 1 and placed back into this bill. It requires the training course. It requires the state police in conjunction with the AG and the Department of Health to go through. This is consistent actually with an amendment that you had proposed. It requires them to go through and put together a curriculum to deal with that will deal with the issues that I read through with regard to what would be required in the training course.
Okay, one final thing. There was discussion, at least I thought in the Senate, about an increased penalty for illegal possession.
There is an increased penalty. I'm sorry. There is. And that was on the very last page, I think. There is an increased penalty. consistent with what was Delegate Conaway's bill here in the House. There is an increased penalty for the wearing and carrying of a firearm if you do not have a permit from 3 to 5 years.
Okay, so we discussed, I was actually angling to get at that section of code. You probably know there's been litigation about that section of code. It's gone to the Maryland Supreme Court, and I'm personally very interested at getting at the culpability problems with that. Is there any way we could send this to conference to consider some culpability amendments?
The motion is to concur.
Okay. All right, but I appreciate the explanation.
Thank you. Delegate Erican.
Thank you. So I just wanted to, I had reached out in between when we had the bill and then when it disappeared to the other chamber. Oh, sorry, you want to yell? I am used to yelling. Just wait till later. So anyways, I reached out to some of the people that do the classes to see sort of how would this bill impact the wear and carry classes and the HQL classes. And so I asked them sort of, you know, with this new stuff, what are we looking at in terms of time commitment? So what they said was that this would take the class from, I think it took me I think it was at least 2 classroom days. It'd probably double that. And then the cost would probably be, I want to say I paid $250 for mine. It would probably be somewhere between $500 and $600, they think, to actually administrate these changes to what's going to be taught in the coursework. So I just wanted to make sure that we understood. And we also asked another group what the demographics were, you know, from last year's wear and carry and HQL classes. Now traditionally this was not true, but today 20% of the people seeking these licenses are female. 30% are now black. So this is a huge increase over the last 10 years. There's additionally another 8.5% who are Hispanic, 6% Asian. So we've seen the demographics of who is applying for this change in the last few years. And I'm a little bit uncomfortable with us potentially increasing the cost by double or more. And I just worry about the impact that's going to have on people having access to this. So I just wanted to make sure that I mentioned that for those who are also worried about people being sort of priced out of the system.
Thank you very much. All right, the motion is the motion to concur. All in favor of the motion to concur, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9. Delegate Taylor, you had your light on? All right, I'm sorry. Delegate Taylor, go ahead.
Yeah, if you don't have if you have a legitimate permit, but you don't have it on you, or your permit is pending, are you still charged, or how does that work when you're?
In cases that I have had, if they have their permit, there is a separate charge if you're not carrying your permit with you. You have to be carrying your permit with you when you are, you're talking the actual card.
Yes.
You have to be carrying your permit with you, and the Maryland permit is what is good in Maryland. You can't. There's not reciprocity. I suspect that will be next year's bill, but there is that.
And if it's pending, you've applied, but you don't use
If
you
it's
just
pending,
can't
you don't
carry
have the
it.
license
You shouldn't
until
have
you
it
have the
until.
license. Correct.
Okay, thanks.
That's right. Do this again. All in favor? Okay. The last word.
If you get caught carrying without their permit on you, is that a criminal offense or a civil?
There is an existing criminal offense if
Okay.
you don't have
Thank
it.
you.
Trying again. All in favor of the motion to concur, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Anyone opposed? 1, 2, 3, 4, 5, 6. The motion to concur is agreed to, and we'll go to the floor.
Can I take 30 seconds to explain my vote? Just 30 seconds?
If you want to take 30 seconds, that's fine. We'll
Yes.
do it right now.
Okay, hold on. I'm trying to put my light on. Okay, I do want to just say that I did vote for it because, in my view, you cannot make the enemy of the good. But I would have preferred, had they passed it clean, that they passed it clean without their amendments. But I do congratulate my good friend Delegate Conaway on getting his bill included in that omnibus bill. Thank you.
Yes.
Thank you, Mr. Chair. So I have some problems with the underlying bill. I think as it came back from the Senate, there are some positive changes, but I have a real problem with tacking a 66% penalty increase on here at the last minute. This particular section of code has been litigated at the Supreme Court several times. And while they have said it's not unconstitutional, they've talked several times about the fact that the way it's structured really tends to dragnet people into criminal prosecutions. For example, the terminology on or about. Frequently what will happen is you'll have a gun in a car, and the way the law applies, you could just arrest everybody. Now, sometimes they do that because they think that the people in the car, they might have a warrant for some of them or all of them, but frequently they're just arresting these people. It gets prosecuted, and these get tossed out. So I think this is the reason that both the gun people and the criminal justice organizations like the Office of the Public Defender and the ACLU are on the same side on this issue. So I think there are problems here. And I think before we just tack such a significant penalty increase, we should really deal with the culpability problems, which do tend to disproportionately impact particular people before we move this on like this. So that's why I'll be a no today.
Thank you very much. We're going to move now to Senate Bill 1. There are amendments that have already been provided to myself, to the committee, and there have been amendments that we have discussed. Or several members of the committee have discussed. I believe Dylan is getting these ready to be distributed. But I'm going to start, well, let's go ahead and let's do that. Should we start with grammars? We can start with grammars. And it's coming out, Dylan, this is Amendment 683128. So when we sent out Senate Bill 1, we thought we had addressed an issue with regard to people being able to transport a firearm, and then we discovered that it went a little too far. And so what this allows, it allows for an exception. Again, this is the bill as it's drafted restricts people from possessing, or from wearing and carrying, I should say, from wearing and carrying a firearm in a sensitive area. This would add an exception that said that the firearm that is carried or transported in a motor vehicle, if it's in a motor vehicle and the firearm is locked in a container or a handgun worn, carried, or transported in compliance with any of the limitations imposed under 5307 of the Public Safety Article by a person to whom a permit to wear, carry, and transport the firearm has been issued under Title V, Subtitle 3 of the Public Safety Article. Delegate Grammer, is this your amendment?
Yeah, and that was a great explanation of it. So just so everybody's clear on what happened, the chair and I talked about this issue, I believe, yesterday. I don't remember what day it is at this point. But what we had thought we had voted on was the elimination of language that made it very problematic to handle guns in cars. What we found after we reassessed the bill was that that was actually not the case. So what this does is it takes language which A was formerly in the bill and B which is in 4203, the 11, I guess, II. That language is taken directly from 4203. So we're really just making the same exception here so that I guess it's kind of like a technical way to achieve what the chair was trying to do. So I'd move the amendment.
I think this addresses an issue. We've gone back and forth about this issue repeatedly, and ultimately we want to put it in basically the same position as what more or less existing law is, and that's what I think this does. All right, so any further discussion on this amendment? 683128. I'm sorry, Delegate Tolles.
I know. Yeah, now don't sweet talk me. So are you going to vote for the bill with this amendment
No,
on
I'm
here?
sorry.
Okay, so
I-
why do you even,
So what we're doing here is, so
no,
this.
I know what we're doing. I'm just saying, so you're not going to vote for the bill?
No, so,
Okay. Thank you, my love.
thank you.
Okay.
Okay. Again, in the opinion of the chair, I think that this is a necessary change to the bill as it's drafted. Any further discussion? Seeing none. All in favor of the amendment, please raise your hands. Anybody opposed? The amendment is adopted. And we'll adopt it as a committee amendment on the floor. Another amendment, this one given to me by a person not on the committee that I would support, comes from Delegate Pippy. Delegate Pippy's amendment in two places in the bill, in SB1, on page 8, line 12, and page 10, line 25. It goes to the crimes that are created when you go to a sensitive place and you're in possession or you're wearing and carrying in those sensitive places or on somebody else's property. It adds a mens rea, it adds sort of an intent to it. So instead of it being a strict liability crime, it would be someone who willfully goes on to the property of another person with the weapon. There's a motion and a second on the amendments. I don't have a problem adding this. We actually discussed this quite a bit in at least in some of my conversations, and I'm willing to take that amendment. Delegate Young.
Just wanting to get a copy of it, that's all.
Oh, I'm sorry. This is 993-428, which you may not have. They don't have that one? Okay. This was given to me. It was given to me because it's outside the committee. It is exactly two lines long. We'll make a copy. Let's do that. But yeah, Delegate Cardin. It adds mens rea to both lines.
The carrying or carrying without permission?
That's the two places in the bill where it creates a penalty. It includes the mens rea on both of those. So it goes to a willfully wearing and carrying at a sensitive location, or a willful wearing and carrying at either a home or at private property.
Right. Well, so my question is, if I give you a hypothetical, my understanding is that if you didn't realize you were carrying, that this would take care of that.
Yes.
Okay. But if you realized you were carrying, but you didn't realize that you weren't allowed to, would this cover that as well?
Yes.
Okay. So that might actually deal with my issue.
Yes.
Might. I'm not sure it does, but it might at least partly.
I think it mostly does, but yes.
Okay.
But I think it also addresses some of the underlying issues that people have raised to say that there needs to be something more than a strict liability crime here, that there needs to be some deliberation about what somebody's doing. My new assistant is passing out the amendments.
Welcome to the district.
Delegate Kaufman.
While our new assistant is passing out the amendments, I do have
Still on a probationary status, everyone.
I do have a question, just so I can be responsible. Am I reading it in my non-lawyer ears that mens rea refers to intent? Is that what it's a synonym for? And if we don't have the committee's time, just tell me how to spell it so I can Google it. Thanks.
No, that it basically goes to the intent to MENSREA.
But you were about to explain it orally. It goes to
Right. So you can do things willfully, you can do things recklessly, you can do things negligently, and there's a scale from a greater level of being deliberate down to a lower level of being deliberate.
Okay, must be a Latin phrase. Okay, thanks.
It is. It's Latin. We swim in Latin.
Okay. Thank you guys for your indulgence.
Thank you. Please file your CLE credit requests immediately. You need it for your Virginia license. Okay. Totally should get that for this. All right. Is there further discussion about this? Again, this is one of the amendments that was going to be offered on the floor, so I would be adopting this as a friendly amendment on the floor. Any further? No? All right, we can now engage in this long debate about whether, because he did leave us. Stop it. All in favor of this amendment, please raise your hands. I know, it's Pippi. All right. Anybody opposed? All right, that amendment is adopted. Well, we will adopt it as a friendly amendment, I should say. Now, let's go to a couple of the chair's amendments. There are three? Two. This one? All right, right? That may be the same. All right. Let's look at 293728. There is a clarifying, or it seeks to be a clarifying change because we discovered that what was supposed to be in one part of the bill was not. Holly, can you explain what this amendment does?
So on page 6, and this was brought up on the floor, it's a section that deals with retired law enforcement officers and officers that are off duty. After speaking with MSB and several others, an off-duty officer, more often than not, after leaving work, they're on, as they call it, 24/7. So this just removes off-duty law enforcement officer from that section where it says wearing, carrying. They're still under police officer, law enforcement official under the bill. This is just that one section that said they have to conceal carry and carry their credentials. We're just taking it out of there so an off-duty law enforcement officer can follow their protocol and is not subject to that subsection there.
There's a motion for the amendment and a second. Is there discussion, Delegate Thompson?
All right, thank you. I just want to make sure I understand this one because I know that there was some chatter yesterday on the floor in my section about particularly off-duty officers, especially, and you didn't just mention this, but especially officers who do kind of part-time work on the side, as security or whatnot. So is what you're saying that they are allowed to carry basically 24 hours, you're saying, or no?
They're going to be subject to whatever their protocol is. Can you wait the mic? Sorry, it's just so slow.
So, Delegate, this is just removing off-duty law enforcement officer from that section so that they're not subject to that new provision that requires them to, as soon as they get off work, conceal if they are still in their outfit and uniform, and they're just going to have to follow their protocol now. Whatever that officer, whatever their employment compliance regulations are, that's what they still have to do. We're not changing anything there. We're removing them from the section that says that they have to conceal carry, and now it just has retired law enforcement there in that one provision, that one section.
Okay.
Okay?
Gotcha.
This fixes the problem that came up on the floor yesterday.
Okay. Gotcha. Thank you.
Any other questions? All right. There's a motion and a second on the amendment. All in favor of the amendment, raise your hands. Anybody opposed? The amendment will be offered as a friendly, or the amendment is adopted. We'll offer it on the floor here in a second. All right, so that's done. So now, this is this. Okay, so now 543221, amendment number 1, is before us, and it addresses what. Actually, Holly, can you tell the committee what this does? It corrects what was, I think, it came to us awkwardly from the Senate, I think. Let's blame them.
So this this amendment is conforming the amendment that aligns the licensing law in 5307 with Senate Bill 1. So right now, there's provisions in the bill that require concealing and carrying. It wasn't put in 5307, and it needs to be to conform and have it make sense. So the Senate had it in SB 1. It got struck in their amendments. And then it needs to go back in, so it should have been brought in when we brought in 5307 in our amendments.
Motion for the amendment and a second. Is there further discussion? Delegate Grammer.
Thank you, Mr. Chair. So am I reading this properly? Currently, we don't have concealed carry. We just have carry. Does this make all carry concealed carry?
It makes all carry concealed carry.
So that hasn't been the case to date. Can you maybe talk about the policy question there? Because that's a really substantial.
I think, first of all, it came over from the Senate in this posture was one thing. So I know it's something that they certainly discussed there. I think that there is a policy question as to whether we want to be an open carry state or a concealed carry state. And I think that the intent of the bill, and certainly the sponsor's intent, was that we would not go and switch to being a completely open carry state with the passage of this bill. So what it's seeking to do is it's seeking to address the sponsor's intent in the legislation. Delegate Arakan.
Okay, I'm just trying to understand the within an enclosed case. So, okay, so B1, big I is the concealed carry part, and then the second one is like if you're just walking, to and from your car with one of your.
And it's in a box.
And again, this only applies to handguns because it's the handgun carry license. Okay. And I guess it's just confusing about what section this is going to go into.
5307. So we struck the provision in the bill for your, if you recall, the 4203. We struck 5307B. The Senate had this language in there, and that needed to come back to make Senate bill and that language in 5307 conform to what is in 307, or in Senate, what is now in Senate Bill 1. So, for example, the amendment we just worked on with the retired law enforcement and off-duty, that language is already in this bill. We've already discussed it at length. This is just conforming it so it makes sense across the board.
Further questions? Seeing none, there was a motion and a second. Oh, I'm sorry, Delegate Munoz.
Thank you, Mr. Chair. So to Delegate Grammer's question, when we pass this, everyone in the state of Maryland who carries a handgun who has this permit or any permit is going to be required to conceal it when transporting it, carrying it, or wearing it. Is that correct?
It would be concealed carry, yes.
And so then would other firearms, anything that's not defined specifically as a handgun, still be open carry, like shotguns?
Like a shotgun or something like that. That's why there's a distinction and why you apply for a wear and carry permit under the law, because that's for regulated firearms, generally speaking, as opposed to unregulated firearms.
Okay. And so this wouldn't affect it being used for
Hunting.
Self-defense?
No, I mean, so the whole, no,
Okay.
it does not.
Or hunting?
Or a rifle or shotgun in hunting, no.
Okay, so the goal...
Or even not a rifle or shotgun in hunting, I guess.
So the goal of this amendment is to ensure that people in the state of Maryland aren't being confronted with these firearms as they go throughout their daily life?
Yes,
Okay, thank you.
thank you. Delegate Arakan, then Grammer.
Dancing. Okay. Okay, sorry. This is actually kind of a big policy change from, the actual bill that we passed. So I just want to understand who this will actually impact. So people like armored car folks, are they exempted from this, or they have to carry concealed? Security guards, those kind of folks.
I mean, so the sense that I have is they're gonna, that if you're talking about a person who's I'm sorry, or like they're the Emmett, one moment.
I also have a question about...
We have multiple questions going on at the
Yeah.
same time, and that's part of the challenge.
Yeah, I also have questions about like special police officers. They're not exempted in this bill. Do they have to carry concealed while they're on duty? So one is about armored car driving people. Obviously, they always carry exposed. The other is special police officers. We did not exempt them. We chose not to. They would also need to carry concealed on the job now.
Yeah, they would need to carry concealed to the extent that they're covered by a wear and carry permit in the first place, yes.
Which is, yeah, that's how they carry. So
Right.
they would have to they have to be able to get a wear and carry permit to get the job as an armored car driver or a special police officer. So
Right.
I think it's going to have the opposite effect of what we're kind of looking for in terms of, you know, having our law enforcement provide sort of a safety where people see, okay, there's an officer here, he's wearing
Again,
a
the
gun.
law enforcement piece of this is not covered by
Right.
this, and
Well,
that's
these
covered
guys
by-
have a similar, you know, like
I understand,
jewelry
but-
stores, banks, those kind of places. They hire people that open carry for a reason.
And there are exceptions under Title V of the public safety article that cover a lot of those people. That whether they cover an armored car company, I'm not aware of that. But having said that, for law enforcement in particular, they would be outside of.
Well, we specifically exempted them from a lot of stuff.
Right.
But I'm not sure if is it the intent that special police officers carry concealed while they're on the job?
I would say that as we've gone through the discussion of this legislation, especially with special police officers, I would say there is a larger conversation that we're going to need to start having regarding special police officers and their training. So if they're required to concealed carry, I think that is probably a very good thing.
Okay, and the same with the armored trucks. That's the intent.
I mean, the intent is, I think that whether or not they are covered under another part of the public safety article, I'd have to go through and double check, but I know that I'm not sure that this necessarily would impact them.
Okay. I think if we could get some clarification on that would be important, because they don't carry concealed. So.
All right. Delegate Grammer. All right. Delegate Simmons, and then Boucher.
Thank you, Mr. Chair. Just wanted to add a little bit context. Special police officers, security guards, armored car drivers, or those who are dealing with an armored car business, anyone in a uniform or reflecting uniform cannot carry a concealed weapon. They don't carry it like on the ankle or anything in that nature. They have to carry open carry. It's a show of a use of force. So at any time they will carry their weapon, it would be in a open carry capacity, not in the concealed, unless they're in plain clothes. Thank you.
Thank you, Chairman. Would this concealed carry amendment in any way put this bill in contradiction to existing Supreme Court case law regarding concealed or open carry? Is there any language in existing case law that this would run against?
No, not to the best of my knowledge.
Okay, thank you.
Not to the best of my knowledge. That's how I can best answer. Delegate Erican.
I'm sorry. So what we just heard from Delegate Simmons is that they're prohibited from carrying concealed. Like, that is a huge problem. So if we've got special police officers prohibited from carrying concealed, and we pass this bill that forces them to carry concealed, we have just passed contradictory laws. So I feel like this has to be addressed before we put this on the floor.
So, under the scope of the subtitle in public safety, and I knew I'd read this somewhere, but I needed to find the exact place. The subtitle, including where this would live, the entire subtitle includes an organization that is required or authorized by federal law governing its specific business or activity to maintain firearms. That would include a armored car driver. That would include, I believe, actually, that would include yeah, if it's authorized under federal law, which is what I think the Delegate Simmons is talking about. So this is already covered here. Right. There are other exceptions in that part of the law as well. Okay. We're on the amendment. It was moved and seconded. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Anyone opposed? 1, 2, 3, 4, 5, 6. 14 to 6, the amendment is adopted. All right. I think those are the amendments that we'll adopt right now as a committee. And so you can ask, so we're not on the bill, we were just taking those amendments up so that they can be considered on the floor, but there are a couple other bills that we need to do. Delegate Card.
Just real quick, I know that we passed the bill, the amendment, the 50 amendment that requires the mens rea.
They can't hear you if you got to let the mic go.
We passed the Pippi amendment that requires the mens rea. This partially, I think partially, maybe completely, but partially deals with the issue of somebody who unknowingly carries onto a property thinking that they're doing it legally, but actually they're doing it illegally. Is there, I just want to bring it up that if you have a church on the property of a school, and there is, the school worries about having an approved list of people that might include people that are not affiliated with the school, I just want to raise it, that you might be creating a situation where people who should be allowed to carry into the church can't because they can't get permission from the school. I'm not saying that this is more of a policy decision than it is, because I think we dealt with the unknowing issue there, although we have to, you're just driving right onto the parking lot and you're automatically, you're knowingly wearing it. You might not realize that you're doing it without the permission of the school. But if, as a policy, we want to allow the people who think they should have the right to do it, we may want to consider that. I'm just putting that out there, Mr. Chair. But
thank you. I feel like we're going to be continuing to work on this for quite a while, but at this point, that's where we are with it as of right now. We have two bills that have come that are before us. One, Senate Bill 57. It has to do with lifetime supervision. There's a motion for a favorable. Is there a second? Second. We passed Delegate Crosby's bill, Senate Bill 57. We passed Delegate Crosby's bill. This is in the same posture as Delegate Crosby's bill some time ago. Okay. This is not medical parole. This is lifetime supervision under. This is Senator Bailey. Senate Bill 57. Senate Bill 57. The other bill that is going to be before us is Senate Bill 164, which addresses issues of driver's licenses and child support arrearages. We're going to get to that. Senate Bill 57 is what's before us right now, and there's a motion for a favorable and a second. All right. Is there discussion on the favorable motion for Senate Bill 57? Delegate Tomlinson. Do you need to remember what this bill does? Great. That's fine. It addresses, the bill expands the definition of a crime of violence under the criminal law article to include sexual abuse of a minor meeting specified criteria, and it expands the list of offenses that subject an offender to lifetime sexual offender supervision. But it limits the situations where that can happen to only those convictions that happen when the person is an adult. It doesn't happen when those people are juveniles, because we didn't want to put a lifetime supervision on somebody who's convicted as a child. All right. Any questions on the bill with the favorable? The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Little Loud? Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right. Now, Senate Bill 164. There have been extensive conversations about this piece of legislation. Some back and forth, and the Speaker's office, who has just apparently left, has had raised some issues. There is a reprint that is heading your way. My understanding of what the amendments do, actually, Counsel, can you speak to what the amendments do to the bill?
Sure. There's striking references to the Maryland Think Network, altering the time for an obligor to appeal to 30 days, and sunsetting the bill after 2 years.
So we're going to be coming back and doing this again in 2 years, and I myself am just very excited about that. But having said that, if it works, it works. So let's try and get going. There's a favorable on the amendment and a second. Discussion on the amendment. Delegate Valentine.
Why would we be coming back in 2 years? I forget what
it's sunset. The bill sunsets in 2 years.
I didn't hear that.
So if you enjoyed this debate once, just wait. Delegate Williams.
I just want to make sure, are both the Senate sponsors okay with all of?
My understanding is in a conversation, a text conversation I had with Senator Watson, he wanted to do something to address the Speaker's office's concerns. Okay. Those concerns have been addressed, as I believe there's a thumbs up somewhere over there. And they're very excited.
Okay, everyone's happy.
So that's where, so allegedly everyone's happy, but when does that actually happen? Delegate Phillips.
I want to make sure I'm clear. So help me understand why the sunset.
They want to see how often this happens, how often it's used. They want to make sure that the department actually can do this and that they don't have problems and that we don't have to come back and really look at this again. So I think that the sunset means that during this term, we will look at it again. My tone is off here only because as Mr. Dews is having an aneurysm in the audience, please do not hurt Mr. Dews any more than that. No, you don't get to talk, so just stop. Okay, thank you. But the goal here, and one of the concerns, is wanting to make sure that they actually could do it, and make sure, which they believe that they can, but we're going to set it in place and then and give it a spin. Delegate Tolles.
Thank you. So the only amendment, just so I'm clear, is the sunset.
I think there was more. There's certainly more than when the House first took it up.
Yeah.
There are amendments that the Senate put on. And then there are amendments that, so
Okay,
look, this still has to get across to the Senate and go through there, but at least by moving it now, we have more of a chance of getting that done than less.
Okay, I see the reprint. So, okay, so when this come back, it will automatically come back to us in 2 years after the sunset, or someone would have to put the bill in?
There'd be another bill.
There'll be another bill,
There'd be
okay.
another bill.
Okay, and are we moving HB, the cross-file, or just the Senate
I
version?
mean, right now, we have to get the Senate version done, and then we will figure out the House. The House version would have a more, yeah, okay. Mr. Dews is, okay. Is having a slightly more challenging time to do that. But I wanted to get this done, being that we don't have a lot of time right this second.
Okay.
To deal with the actual policy. Delegate Cardin, Delegate,
I'm good with this. I just wanted, is there a reason why we changed the appeal from 45 days to 30 days? Was there, I mean, it's fine.
I think it was in the Senate, it was in the Senate language where they did that, and they changed it to 30 days, so.
So you're giving people.
And it's what DHS wanted. Yeah.
Okay, because 30 days is usually what it is in the
Yes.
circuit court anyway. Okay, thank you.
Delegate Munoz, I know, I hear you, okay.
Mr. Chair, can you remind us, was there originally opposition to this?
I think that there was concern, there has been concern in the past. The question is always between the tension between making sure that people pay their child support. I think that what the bigger concern here is that we have other mechanisms to make sure that people pay their child support, whether it's in withholding wages or in some cases criminal incarceration. The thought here is that by making sure that we make it more difficult, I think, to suspend people's driver's licenses, it removes a barrier so that people can continue to work, so that they can make the money to pay their child support. And so, again, there is that tension that is there, but that's why we're here.
And I believe we had mothers testify that they
Right.
would benefit and have more help with the father being able to drive, or whoever.
That's one of the things. I wonder what Delegate Grammer is about to ask.
I was just going to say, Mr. Chair, that there aren't any letters of opposition on both the
That's
Senate
right.
and the House. So,
You're moving the. Well, we have to let Delegate Grammer have some fun. Would you like to move the previous question? All right, there's a motion to move the previous question. All in favor say aye. Opposed, no. Motion's adopted. We're on the bill as amended. We adopted the amendments. No, we didn't. All in favor of the amendments, raise your hands. Anybody opposed? Seeing none. There's a motion for favorable as amended and a second. Any further discussion? I don't think there is. The Vice Chair, yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? No. Phillips? Yes. Tomlinson? Yes. Yes, and yes.
All right, thanks. I was kind of mixed on this bill for a while, but the amendment, I think, helps convince me, especially with the sunset 2 years. I know there's a lot of discussion. I think just today it was brought up, the difference between a privilege and a right, and obviously licenses are considered a privilege, but they might be a privilege, but I think they're a necessity. And just like it was brought up by the sponsors and the advocates, I mean, you can't expect somebody, whether you're taking someone's license away for not paying their taxes, which I know folks are in that situation back in Carroll County, or whether it's asking people to pay child support and you strip them of a license. There's no way you can, in most areas, unless you live in an area with a really good public transit system, you expect these people to ever actually work and pay off these bills. So I appreciate the amendment. It definitely helped convince me. Thank you.
All right. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Motion is adopted. Okay. We are going to stop for right now, and we are going to go to the floor and give people the opportunity to get to the floor. We thank you all very much. This has been a hearing or a vote session for the House Judiciary Committee.